Gentlemen, if everybody can please have a seat. We will call tonight's meeting into order. Today is Tuesday, January 9th, 5 p.m. We will call the meeting into order. Madam Clerk, if you'll take the roll, please.
Yes, Mayor. Mayor Danziger.
Present.
Vice Mayor Rose.
Here.
Commissioner Landsman.
Present.
Commissioner Mashite.
Present.
Commissioner Velasquez. Absent. Mayor, you have a quorum.
Thank you. Chief, if you'll lead us, please, in the Pledge of Allegiance.
Republic for which it stands, one nation, under God, indivisible, liberty.
Thank you, Chief. Moving on to item 2, Quasi-Judicial hearing. Madam Attorney, do you have a statement you want to read?
Opening remarks. Thank you, Mayor. I'll read my spiel here. This evening's special meeting of the Town Commission is an in-person meeting as set forth in the Town Code. Applications 2A and 2B on the special meeting agenda are quasi-judicial in nature. Following the presentations by staff and the applicant, the Commission can take public comment. Following public comment, the applicant will be entitled an opportunity for rebuttal. Following rebuttal, the Commission can ask questions, make comments, and deliberate on the resolution. The quasi-judicial procedures require this Commission to consider the evidence presented to it and base its decision on the applicable law and primarily on the evidence presented, whether by the applicant, staff, or members of the public. For special agenda item 2A, that's a site plan and a conditional use request. The criteria for that are set forth in sections 90-20, 90-35, and 90-37, and 90-41. Special agenda item 2B is a site plan amendment and conditional use. I'm sorry, is special item 2B is a variance application. The criteria for that is set forth in section 90-36. The evidence considered must be substantial competent evidence. This means testimony or other evidence based on personal observation or relevant expert testimony that a reasonable mind would accept as adequate to support a conclusion. It is not a popularity contest. It cannot be based solely on non-expert opinions, no matter how fervent those opinions might be. Everyone who seeks to speak on an item will be given an opportunity to speak. If you intend to provide testimony as to any of the applications considered at this special meeting, you will be sworn in before your testimony is taken. Please know if you do speak, you may be subject to cross-examination. If you refuse either to be cross-examined or to be sworn, your testimony will be considered in that context and given its due weight. The general public will not be permitted to cross-examine witnesses, but the public may request the Commission to direct questions on their behalf to either staff or the applicant. At this time, anyone who wishes to speak should be sworn in. Madam Clerk, please administer the oath.
Please stand. Do you swear or affirm? If you're speaking on any of the next 2 items, please stand. Do you swear or affirm to say the truth and only but the truth? You may be seated.
Madam Clerk, one more thing. Can you confirm compliance with the advertising notice requirements?
Confirm.
Thank you. Mayor and Commissioners, have any of you had any ex parte communications with either of the applicants or any member of the public, either for or against any of the applications on this special meeting? If so, please state for the record who the communication was with and the nature of the communication.
None.
Okay, the record can reflect that none have, that there were no discussions outside of this hearing. Mayor, I turn the proceedings over to you to begin the hearing with the recommendations of the town planner for whichever item you want to start with. And I apologize in advance because you're going to hear all this again next meeting.
Thank you, Madam Attorney. Moving on to item 2A, 9133 Collins Avenue, site plan amendment and conditional use application. Madam Clerk, if we read the title of this very long ordinance into the record, please.
A resolution of the Town Commission of the Town of Surfside, Florida, approving or denying a site plan amendment application for the property located at 9133, 9149 Collins Avenue, Surfside, Florida, to amend the number of residential units and abandon the hotel use as originally approved by resolution number 2018-2489 and later amended by resolution number 2021-2782, changing from 29 residential units and 26 hotel units to 24 residential units with 7 caretaker units and no hotel units, approving or denying a conditional use application to allow to allow an accessory restaurant pursuant to section 90-41 of the Town Code, retaining site plan and conditional use approvals, conditions, and all other aspects of the original approval set forth in resolution numbers 2018 2489 and 2021 2782, providing for conditions, providing for violations of conditions, providing for severability clause, and providing for an effective date. Item 2A.
Thank you, Madam Clerk. Well done. Mr. Manager, I'll turn it over to you.
Mayor and Town Commission, thank you very much. Happy New Year's. We have Walter Keller here to guide you through this process. Walter is yours. Thank you.
Mayor, Town Commissioners, my name is Walter Keller with Marlin Engineering, and I'm Town's consultant planner. This application's request for a site plan amendment for 9133 to 9149 Collins Avenue, known as the Seaway. The most recent site plan approval occurred in April 13th, 2021, when it was adopted by the Town Commission. During this approval, the number of condominium units was reduced to 29, and the hotel was reduced to 26 hotel rooms. The underground garage was expanded to 58,242 square feet, and modification of balconies occurred on levels 2 through 12. I read you this because this is an active project. It has been. Shortly thereafter, approval was given for the foundation permit, and the building was put under construction. This current request, and I'll summarize again what's being done, is to reduce the number of condominium units from 29 to 24, through totally remove the hotel and the 26 hotel rooms, retain the restaurant that was previously approved when the prior site plans were done, but increase the restaurant from 1,100 square feet to 8,529 square feet. And note that the restaurant is in the old historic part of the building that was retained. It also includes minor landscape and deck revisions in the courtyard of the historic Seaway Villas and 7 caretaker quarters on levels 3 and 4. One of the things that can occur once the hotel is taken out, the hotel rooms are taken out, and the condos are reduced, it frees up more parking that can be used for the restaurant. The restaurant will now be done as a separate approval as part of the site plan tonight, where previously it was part of the hotel. It's now a conditional use. In addition to that, we have 7 caretaker units. These are units that cannot be sold. They can only be sold to unit owners, and they're very small, and we have assigned parking spaces for them. The design review group met on November 17th, 2023 to discuss this project and review the site plan requests. The DRG agreed to move the site plan to the Planning and Zoning Board. The Planning and Zoning Board considered the site plan amendments at its meeting of November 30th, 2023, and the board recommended the commission approve the site plan amendment considering the staff review comments. So as with any multifamily project like this, we have to go through section 90-20-2, A of the zoning code. And I apologize, it's a little lengthy, but for the record, we need to put this information in. 1, the development as proposed conforms to the comprehensive plan and to the zoning code. This proposal complies with the town comprehensive plan in that the development is a residential use at a density consistent with the future land use plan. Staff also finds that the proposal generally complies with the zoning code. 2, the development as proposed will have a favorable or an unfavorable impact on the environment and natural resource, including consideration of the means and estimated costs necessary to minimize the adverse impacts, if any. This project has minimal impacts on the environment and natural resources. And essentially, the amendments to the site plan are not changing any of the size of the building. It's just changing things internal to the building. The development as proposed will have a favorable or unfavorable impact on the economy of the town of Surfside. This proposal will have a positive impact on the local economy by increasing the tax base. The redevelopment may also support other redevelopment in the area. The historic Seaway Villas restaurant will provide a unique restaurant experience for the town. The development as proposed will efficiently use or unduly burden water, sewer, solid waste disposal, education, recreation, or other necessary public facilities which have been constructed or planned or budgeted for construction in the area. While the increase in the restaurant size will increase some public facility demands, it will not offset the reduction in the dwelling units and the elimination of the hotel and their reduction in the water, sewer, solid waste, and other public facilities. Next, the development as proposed will efficiently use or unduly burden or affect public transportation facilities, including mass transit, public streets, and roads, which have been planned or budgeted for construction in the area, and if the development is or will be accessible by private or public roads or streets. It is expected the reduction in the dwelling units and the elimination of hotel use will offset any increases associated with the increased traffic associated with the restaurant expansion. The development as proposed is consistent with the community character of the immediate neighborhood. In addition to consistency, there must be congruity between the subject development and neighboring improvements and surroundings, including but not limited to form, spacing, heights, setbacks, materials, color, rhythm, and pattern, or architectural or aesthetic interests or value, as well as any overlays and other development schemes or legislation. The current building exterior will remain the same, and the historic Seaway Villas restaurant use will be compatible with the community character of the area. In the event of redevelopment, the applicant shall also submit a detailed plan for demolition. The applicant will comply with all applicable requirements of ordinance number 2022-1720, adopted March 8, 2022, regarding construction site. It is recommended the Town Commission approve the site plan amendment and conditional use for restaurant use, subject to the following comments. Now, I will say that some of these comments have been addressed in additional stuff that they've done, but we still will include them as part of the record to make sure on the final sign-off that they're taken care of. Clearly demonstrate the restaurant parking requirements, the parking requirements for the 7 caretaker units, and the parking requirements for the residential condominium units are met with a number of parking spaces in the garage. Verify the total area of the restaurant, including customer service area, both internal and external in the courtyard, the kitchen area, and any kitchen back of house floor area do not exceed 5% of the total building floor area. Next, the letter of intent must reflect back of house and total restaurant square footage, as this is part of the conditional use approval process. Restricted covenant over the caretaker units to be sold in conjunction with the main unity, caretaker units defined in Code Section 90-2. A parking utilization study after operations are functioning may allow for a greater number of seats. This provision to be added to development order or to permit administrative review. And those are our recommends for this project. I'd be happy to answer any questions.
Thank you, Mr. Keller. Does the applicant want to words?
Good evening, Ian DeMello from the Shubin Law Group, 100 Southeast 2nd Street, on behalf of SCR Trust LLC for the Seaway at 9133 Collins Avenue. Thank you, Mr. Keller, for your thorough review. As mentioned, there are no proposed revisions to the exterior of the project aside from some landscaping revisions. We're very excited about implementing the ordinance that you all passed a few months ago and opening up these new restaurant spaces. With that, I'm not going to go through the changes because I think they're pretty self-explanatory. We'll reserve those for any questions you may have. But we would like to show you some of the interior spaces, the renderings that are proposed for the restaurant. Here we have on the ground floor of the historic Seaway building. And Bill, if there's anything you want to add as I go through this, please chime in. There'll be a nice spiral staircase going up to the 2nd floor. Here we have an image of the 2nd floor space. Another area of the dining. Yet another. And then here's the courtyard again, where we'll have the outdoor dining space, which is all was actually previously approved. Really, we're just expanding the interior space of the restaurant. We do have some limited landscape revisions. We are changing the architect, some paving materials in the pool area, and we're also changing the plant species. And here's a sampling of how the pool will look with the new paving. And here's the seaway. As you know, you've probably seen, construction's underway. It's in place, and this will be the main entrance to the restaurant area and the courtyard. With that, I'll turn it over to Bill. Has any additional anything to add?
Bill Thompson, 300 Ridgewood Road, Key Biscayne. Hi, everybody. Right now, it's programmed for 2 restaurants. One's called Jandal, which is a big hit in Ibiza. And the other one is a brand of Kosaka, so that you'll have a kind of like a Mediterranean and also, I don't know, they're like, sushi. Yeah, my guys are sophisticated, you know. Anyway, I think it kind of brings 2 new venues to the town, and we're super excited about the interior because it kind of like takes you back in, which is in kind of congruent with what we're trying to do with Seaway. So I really think it turned out nice.
Thank you. With that, I'll close our portion, reserved for questions. As staff said, we comply with all conditions and requirements under your code and comprehensive plan, including all requirements for conditional use approval. Thank you.
All right, thank you. At this time, I'll open up the public comment. Mr. Kruslus, I just need to understand for the record, are you currently employed by Ford Partners?
George Kuslis. I am employed by Fort Partners on a separate project.
I believe you have to be registered as a lobbyist to speak on behalf of the applicant or the project.
Register after the fact then, but it's clear, it's on the record,
What is on the record, Mr. Kuzlis?
that I am working for Fort Partners on their surf house project.
Got it. I appreciate that, but what? But you're not registered as a lobbyist, correct?
No,
Okay. I mean, I don't think there's any. I'm going to leave it up to the commission. You know, he can register after, but he should register before. Please.
sure. George Kuslis, 9225 Collins Avenue. What started out as an excellent project a few years ago has really only gotten better with this modification. As you heard, most of the changes are internal, or they're all internal except for landscaping. The project has fewer units, the project has lost the hotel, and the project is gaining a larger restaurant. And if there's anything we've learned over the past half decade at this point, is that we can all enjoy what has happened at the surf club because of this developer, and whether we can afford a $500 meal or just a cocktail, the experience of enjoying what they've done there is fantastic, and basically bringing a public use that any resident or anybody can take part in this makes it much more than just a condominium project, however luxurious it may be. So I hope you would approve this thing, and certainly take my employment on other matters with this developer into account, but I think the project speaks for itself. Thank you.
Thank you, Mr. Kuzlis. I have no other public comment. I'm assuming you don't want to rebut that? All right. Can we get a motion on the table?
No comments? I'll make a motion to approve.
There's
With conditions. I'll second.
Excuse me, Mayor, may I make one notation for the record?
Sure.
You guys have a revised version of the resolution that was circulated to you via email and is in front of you on the dais. There's one minor change to that. It's on page 3 of 8. It is special condition A1. And the revised condition reads, prior to any certificate of occupancy, the applicant shall execute and record a declaration of use in form and substance acceptable to the town attorney, providing that only unit owners can own or rent caretaker units. Period. Thank you.
Thank you.
I'm okay with that addition.
Resecond, yes.
All right. Any questions or comments for the town, for the developers?
I just had one. Thank you for bringing this project forward. I'm glad you guys eliminated the hotel. I guess the only question I had is, do you know if the restaurants are going to be open on Saturday?
24/7. No, I'm just kidding.
But you should be open on Saturday, right? Saturday night, big night, Saturday.
Four Seasons is open on Saturdays.
That's
We're
what I
open on
figured.
Sundays too.
Thank you, Bill.
Commissioner.
I like to just make a comment that I appreciate, I like how this developer always respects our town compliance and process with our code. And I look forward to new restaurants in the community and a historic landmark that everyone loves. Thank you.
Thought that was off. I apologize. It was perfect timing anyways.
Just a comment as well, no questions. I agree, it's a continuation of a great project, making it better, less units, obviously bigger units, but less units, less traffic, then less parking for the condominiums, the hotel. Probably not the focal point of this project to begin with, but now we have more units, more people that will be residents of ours, not necessarily traffic. And then I agree, the additional restaurant options, 2 of them, will be great for the community. So, no, well done.
Just going to echo their comments without getting into it. All right, Madam Clerk, you want to call the roll, please?
Commissioner Lansman,
Yes.
Commissioner Mashine,
Yes.
Commissioner Velasquez is absent. Vice Mayor Rose,
Yes.
Mayor Danziger,
Yes.
Mayor, the motion carries.
Thank you. All right, congratulations. Moving on to item 2B, 9341 Bay Drive, variance. Madam Clerk, if you'll read the title of the resolution into the record, please.
Yes, Mayor. Resolution of the Town Commission of the Town of Surfside, Florida, approving or denying a variance application for property located at 9341 Bay Drive, Surfside, Florida, to allow a primary frontage setback for a through lot with 2 primary frontages of 10 feet where a minimum setback of 20 feet is required on Bay Drive, addressing violations of conditions, providing for a servability clause, and providing for an effective date. Item 2B.
Thank you, Madam Clerk. Mr. Manager, I'll turn it over to you.
Thank you very much. Prior to me turning it over to Judith, our town planner, who will introduce you and walk you through this project, I'd like to confirm something with the town attorney. I believe for this variance, supermajority approval is required.
4 votes. That's correct.
Thank you. Just as a point of information, Mayor. With that said, I'll turn it over to the town.
Is it 4 votes or a supermajority of the ones present?
That's what I want to confirm with the absence of an elected official.
4 votes.
All right.
So with that said, I'll turn it over to our town planner. Thank you, Judith.
Good evening, Judith Frankel, Town Planner. This is 9341 Bay Drive. We're looking at a setback variance application. The homeowner is applying for an unnecessary and undue hardship variance for the Bay Drive frontage setback at their property. The lot is atypical for Surfside as it is triangular in shape. Zoning code states that the front of the lot is construed to be the portion nearest the street, and for corner lots, the front shall be the narrowest portion abutting the street. In this case, the Dickens Avenue side of the lot is the narrowest portion of the property abutting a street. The house on the Dickens Avenue side is set back 20 feet. At the south property line, Bay Drive and Dickens Avenue are parallel before they intersect at the northern end of the lot. The functional front of the property is on Bay Drive, where the home is currently set back 15 feet from the front property line. The homeowner is requesting this variance to be able to build an addition that would be set back 10 feet from the property line. They are seeking to add a small addition to the functional front of the home. The addition would add 342 square feet to the home and increase the general functionality of the residence. The site plan demonstrates that with the proposed addition, the home only occupies 40% of the lot, which is below the 50% maximum allowed for one-story homes. The hardship of the unusual lot shape was not created by the applicant, and the addition maintains the 10-foot setback, which would be typical of corner lots. A literal enforcement of the zoning code would result in a reduction of the existing setback, as the existing setback is 15, and place an unnecessary and undue hardship on this property. The Planning and Zoning Board at the November 30th meeting approved the application for the addition with the condition that the Town Commission approves this variance application. The board recommended approval of the variance application. Town staff has determined the setback variance application to be in harmony with the general intent and purpose of the town comprehensive plan and town code and recommends approval. In your packet, in the staff report, goes over all of the criteria laid out in our code that was required of a variance, and staff has determined that they have met all of those requirements. The applicant, the homeowners, are here along with their architect. They don't have a formal presentation, as I think everything is laid out before you, but they're here to answer.
Thank you, Madam Planner. Let's do public comment. Mr. Kouslis, 2 minutes, please.
George Kouslis, 9225 Collins Avenue. Variances under our zoning code are a big deal. You heard that you need more than the usual, the customary 3 out of 5 votes to pass one. It's set apart from other approvals by its nature in Part 2 of Chapter 90. And one of the things that's laid out, and you see in your packet, is a set of 8 criteria that the applicant must basically say, this is what's going on, and this is why I comply with it or meet the criteria, and therefore I need a variance. You need a score out of 8 out of 8. 7 out of 8 isn't good enough. And none of this has been done. You have a simple letter stating that the lot is kind of crazy, and which it is, and that a variance is desired and requested. This process is arduous, and it's detailed, and it's very specific for a reason, and we don't just grant variances. So I think you should take that into account when you consider whether to grant this variance or not. None of those 8 criteria have been addressed by the applicant in writing as part of their application. Thank you. And that's been done on just about it has been done on every variance application that's been before you in the past. It's all been enumerated. Thank you.
Thank you, Mr. Kouslis. Seeing no other public comment, I'm going to close the public comment portion and open it up for the commission. If you have any questions or comments?
I will ask the town planners, is Mr. Kouslis correct? Is there something that we're missing here to be able to effectively determine this variance approval?
So if you look at the staff report that we prepared, I go over all of those 8 points and how this project addresses all of those points. And the application that is there before you clearly shows. I can go through them one by one if you like, but I've addressed all of them in the report. Do you want me to address them one by one?
For me, it's in the report.
To the mayor, we defer to the report, and if you have any specific questions towards the report.
My comments on this variance, I've sat in over the last 10 years Several P&Z meetings where variances were proposed, and it is a vigorous process, but I didn't see this applicant following it. I see staff notes, but typically the person asking for the variance, it's a very nice letter, but I would like to see each of the 8 criteria written by the person, the applicant for the variance. I'm just used to seeing this, so I think that the applicant needs to come back and state each of the 8 criteria where they feel like they meet it. I mean, again, a very nice letter, but I would like to see that, and I would consider approval at a later date.
Through the mayor, the applicant is here. If you wish to ask any questions to the applicant directly, I would.
And-
So
Recommend that.
before I'd like to make a motion to approve, I just want to ask a question to Commissioner Maishai. If that's okay, Mr. Mayor. So you want them to rewrite it. We're going to get the same answer that the town planner is going to analyze, exactly the same. It's going to meet the criteria, even though it meets it here, just on the architect's letterhead. We're going to come to the same conclusion. Even though, because she's going to analyze it the same way, you're going to get the same result printed out. That's what you want them to do?
This is the responsibility of the applicant, and
But,
that's what I have seen in the past. And I would like to see the applicant take the responsibility to address each of the 8 criteria, not staff.
If I may, the applicant's architect prepared the plans that you see, and I think the plans.
I see the plans and I see the letter, but I'm used to seeing the 8 criteria spelled out by the applicant.
I think the plans give you the answer. That's what I would say, that the
It's
plans.
the same conclusion.
I was going to say, this is
Same
the
answer.
second impractical variance that this commission had to consider in our 2 years. So I don't know what we're getting used to, but I think it's not behooving for us to punish the applicant because of who prepared the letter. As a matter of fact, if staff prepares it, I think it's an unbiased opinion versus if somebody prepared it themselves. That could be the complaint, that of course they're biased to every 8 criteria. But to me, if staff is filling it out and going through each of those 8 criteria, I think that's coming from an unbiased point of view, and that actually holds more weight to me. So unfortunately, it seems like there needs 4 on this, but I would recommend that if you have any questions, you ask the applicant, as they've taken the time to be here and prepare this, rather than punish them for whose letterhead this letter is on.
I'm not punishing them. I'm asking them to do their responsibility of doing the right application.
I'm not going to get into semantics, Commissioner, but that's what you're doing.
Is that required for the architect to type it up, or is it required for us to see the 8? Because it seems there's a little bit of semantics right here.
It's required that those 8 points are addressed.
And you address them and review them, and they're met?
Yes. And the application was prepared by the homeowner, who is
Right.
a homeowner and not a,
Correct.
as I'm aware. And so they contacted me, as typical as in these cases. People want to do an addition, they contact me, I go over the zoning code with them, I met with them. We reviewed what the criteria were. I felt they met the criteria in order to bring it to planning and zoning. The consensus at planning and zoning is that this is the type of project that the variance exception exists for. I believe that was the words of the core in this case.
Can I ask you how many properties fall under this?
Yes. And they did pay the application fee and completed
Variance
paperwork,
fee.
and we accepted it.
But they didn't write it themselves.
Mayor, in all fairness, this is an application put together by a homeowner. We are the party to evaluate and provide a recommendation, and we just hope you accept it the way it's presented, as we're trying to assist the homeowner at least in mitigating some costs in this process.
Well, if I could just, I had that one question, if you don't mind, Commissioner. How many properties fall under this technicality, I guess?
I mean, well, anyone can ask for a variance, so that's a tricky one.
Oh, but this specific one, I guess.
Of a triangle.
Yep.
I mean, off the top of my head, I can think of one other one. We did hear, and I'm not sure whether it was this commission, the last variance that I remember was 8705 Carlisle.
Probably about I mean, triangle ones are different because half of the sky is a triangle, just a reverse pi, but then there are some other ones down the street, but yeah. This is a textbook variance.
I can think of only other one that's like this, where it really only has 3 sides.
Yeah.
3 true sides.
On Bay Drive in 90.
And in looking at this and in making this determination, you can see that when this house was built, they had a little bit trouble deciding which one was the front, because on Bay Drive, it's 15 feet. On the south side, it's only a 5-foot setback. So whoever planned that considered that to be one of an interior side, which is and then on the north side to where the property essentially comes to a point, it's 40 plus.
I think that was my point. This is an irregularity, and it falls under what would be a textbook impractical variance.
Mr. Mayor, so let me first second the motion from the Vice Mayor, so that's on the record. We have a motion and a second. And my comments, I agree, we've been here almost 2 years. I think this is the second variance we've looked at. Variances are not often requested and in general terms, they are difficult to get approved. That is true, but for the most part, most requests for variances are typically for larger developments, much more comprehensive, much more relevant to, much more substantial. This is a single-family home. I happen to know it very well. I pass by it every day. It's right down the street from me. I know where it is. It's a very interesting shaped lot. The homeowners are looking to simply add several hundred square feet. It's only a 5-foot difference in the setback. So this is not earth-shattering. This is not a massive request. And yes, this is a homeowner, not a developer like Fort Capital looking for something unique or a waterfront home. So I do think we can look at this differently if, in fact, the conditions were addressed and staff agrees with it, staff put it in the order. I feel comfortable that we can approve it, but we need 4 votes, and there's 4 of us here, so we'll see how it goes.
Yeah, this is not a new house asking for an addition. This is a resident asking for a small, modest addition, and they didn't tear down their house and build a new one. I think this is textbook. So for me, I support it. I don't know, Commissioner Maishai, what's going to take for you. If you want to put the resident, so you want to put the resident through to come back next month and just rewrite a letter with the same outcome, that's okay if that's what you want, but don't waver if that's what you want. Say
that's
it.
simply, I mean, I only see that they answered number 1, but I would just like to see that the process is followed correctly, and I would definitely consider it at a later date. I just want to see each of the 8 criteria answered by the applicant.
Is there a process in our code that the homeowner has to write this or that you have to review it?
The applicant.
The manager answered that, but
It's for my town planner.
Yep.
Wait a minute.
Through the mayor, there is no process. I do see the applicant raising their hands. If you want to give them a chance to say something.
Excuse me, sorry. Can you please state your name and address for the record?
Yes. My name is Sandra Sous. I live in 9341 Bay Drive. From the day I bought my house, my poor husband has been listening to me saying, I need a place to set a Shabbat table. I need to be able to host. And this is the only reason, basically, that poor guy, has suffered, but I wanted to just make this happen. We came to shoot it. They have been amazing helping us. And we went over the 8 points. They were addressed. So I really apologize if we didn't do it the perfect way. We are homeowners like the rest of the people set here. We're just trying to make it, more comfortable, the layout inside. And to do that, we needed that extra, I think we're talking about 300 square feet that we are trying to add here. I'm not very familiar with all the technicalities, and that's why we really use all the support from the town, which they have been amazing and they have been giving us. And my understanding is that we needed to pass those 8 criteria, and we did. I just didn't know myself we needed to put it in a letter. Every time we come to a hearing here, I took the time to send whatever amount of letters that needed to inform all our neighbors. It's really, they even asked me to send them via certified letter. I did everything I understood needed to be done by the book as much as I could. So I really apologize if perfect case, but I really ask you if you can please consider approving it, because the only thing that we need is to start this project that it started basically, me knocking on my husband's head a couple of years ago. And I understand we may have, not made it perfect, but I do not know if it's so important that, it comes from us, as long as those 8 points were addressed and we are in compliance with everything that needs to happen to get the variance. And I even think I heard, but correct me if I'm wrong, I think there was another land very similar, and this was already approved by, back in the days. So that's why we were expecting to, get to a great finale today to start our own project. Thank you.
So we call the vote?
Well, I have a question before we call the vote, because if it doesn't go through, does it have to go back to P&Z? What's the?
If I may,
I know it can come back next month.
If it doesn't go through, it's denied. So it would have to be either reconsidered by someone on the prevailing side of the motion, which would be
3 people that voted for it.
Yeah, whoever voted against it under that scenario.
So whoever voted against.
Or it's dead and there's no application. They would have to reapply if they wanted to seek it.
And pay the whole variance fee and send all the certified letters again,
That's correct.
just for a letter. Okay. Just.
So, through the mayor, so I believe your problem is with me. If there is a fault, it's mine. I accepted the application. I looked at it. I worked with the homeowner and created the staff report. I don't know if it's possible, if the only way for you to be satisfied is to have the homeowner write the letter to defer or continue the item so that they do not have to be, the homeowners have to be penalized for my error, because they did go through the expense of doing all of the noticing and paying the variance application fee. So that's what I would ask.
I mean, Commissioner Marshall, it's up to you. Would you feel more
Well,
comfortable if I take a break for 10 minutes and write
I
something?
really just want to stick to the process, and perhaps you're correct in that. So if it's better to defer it, I mean, it's not like I'm opposed to it, but I do want to stick to the process. And
I don't believe that we followed the process incorrectly.
Through the mayor, we followed the process. The process was just, if there was a previous way of how something was done, that is one thing, but that doesn't mean that was the process. We followed the process. We evaluated the application on the 8 merits, and we provided you the recommendation. I just really want to anchor that point. I know Judith has taken fault, but this isn't, I respect that, Judith. I really do. We're just trying to do something good for the homeowner. We evaluated the situation and provided to you for a vote.
and I don't want to cause the homeowner any additional expenses or anything, but I would like to see, to me, they've only answered number 1, and I would like to see all 8 criteria answered by the applicant.
So would you be comfortable taking a 10-minute recess and they write it out for you? 1 through 8? That's what you wanted to see in writing. We can do, because if not, they're going to have to come back next month. They're going to have to pay the fee, send all the certified letters. That's the reality. You can say all the things you want, but at the end of the day, if it's not done today, there's the expense incurred. So I'd be comfortable doing a 10-minute recess and letting them write out whatever you want to see so we can move forward.
Judith, did you offer another recommendation to defer?
I'm not making any recommendations.
No, I mean, if it was deferred, then they wouldn't incur any additional
Yes.
expense.
They have
Is
to
that
send,
correct?
they have to resend certified letters with the new date of application.
If it's deferred to a date certain, I don't believe you have to renotice or send applications. But you would have to state the date today it's deferred to.
If I may, the requirement, the specific requirement in the code says that there's an application and it's got requirements of that application, okay? And then in a separate section, so it's not a requirement of the application. What it says is that in terms of the standards for review, the applicant shall demonstrate by clear and convincing evidence that all of the following are met and satisfied. If it would help bridge this gap, the applicant could read that section of the staff report into the record, and we have it in the record, if that's the will of this commission.
Well, in their own words, I mean, again, the letter to me answers the number 1 criteria, which is fine. So in their own words, you're saying to, I don't know if that would suffice.
Well, to be clear, again, there's no requirement, so it's what do you consider sufficient? Do you want them to say in their own words how number 2, they didn't create the circumstance and the block was like that when they moved in?
Yes, yes. Yeah.
So we can
Okay.
have him read it in his own words if you'd like.
Let's do it.
How do
For
we
residents.
move forward on this?
Commissioner Marshall, that was
Does it have to be?
that was a recommendation.
Mr. Resio, so can it be verbal or?
It can be verbal, yes. It just has to be demonstrated.
I would love to do this for the resident. I'll sit here and absolutely help them await, if that's okay with you, Commissioner Maishad. Verbally.
I want the applicant
Yeah.
to do it.
Beautiful.
Again, I want to hear it. Then if it can be verbal, let's try that. But be specific how your criteria meets it.
Okay, so this is 1, 2, 3. Okay, criteria number 1. The special conditions and circumstances exist and are peculiar to the land, structure of the or building involved. Which are
Can you, what page are you reading from?
49.
Page 65 in your
in our
book.
books.
It's 1 through 8.
What is it?
49.
Okay, thank you.
So first item, special conditions or circumstances exist which are peculiar to the land, structure, or building involved, and which are not applicable to other land, structures, or buildings in this zoning district. The answer to that, to be able to comply, is that the lot has a triangular shape, as we can see on the picture, and is classified as a thorough lot, although the layout is more typical of a corner lot.
Agreed.
The second item, the special conditions and circumstances do not involve the actions of the applicant or a prior owner of the property. The answer to that is the special platting. So I didn't do anything to create the drawing of the way the house was situated in the land we bought. Item number 3. Literal interpretation of the provisions of the zoning code deprives the applicant of rights commonly enjoyed by other properties and results in unnecessary and undue hardship on the applicant. So the answer to item number 3 is that without the variance, this lot would be required to have additional setback space not typically required on corner lots. So the corner lots do not have the same requirements that my lot has, although my pretty much is at the end of the street. Item number 4. The hardship has not been deliberately or knowingly created or suffered to establish a use or structure which is not otherwise consistent with the or the zoning code. The answer to item number 4. The hardship of a lot dimensions was not created by the applicant. So I did not create the size of the lot. Number 5. An applicant's desire or ability to achieve greater financial return or maximum financial return from this property does not constitute hardship. The proposed addition, the answer. The proposed addition is small and will provide greater functionality to the home. As I said, basically, I just want to have a table on my dining room. I don't think. Number 6. Granting the variance application conveys the same treatment to the applicant as to the owner of other land structures in the same zoning district. The answer. A 10-foot setback is typical on a secondary frontage on corner lot. So other corner lots have the 10-foot frontage and mine does not. Item number 7. The requested variance is the minimum variance that makes possible the reasonable use of the land, building, or structure. Okay, so the answer. And the addition reduces the existing setbacks by 5 feet. So I'm moving 10 feet and still maintain a 10-foot setback typical of a corner lot. The item number 8. The requested variance is in harmony with the general intent and purpose of the town comprehensive plan and the zoning code. Is not injurious to the neighborhood or otherwise detrimental to the public safety and welfare is compatible with the neighborhood and will not substantially diminish values within the neighborhood. Well, without reading, I don't think that it will affect the value of anyone. The setback variance is determined to be in harmony with the general intent and purpose of the town comprehensive plan and town code. I don't think that having a dining table, will affect the other neighbors around me.
Thank you.
Did I go over all the 8 points?
Yes, you did. I hope in the future we can keep in mind if we have variances that and I'm sure this is not going to happen again to you, but there is a process that I've sat through where the applicant does go through this in their own words. So, yes, thank you very much.
Thank you.
Through the mayor, if I may, just as a point, if we want to establish the processes, can you please have a discussion item on this regards, because we followed our process. I want to be clear because we have staff taking blame for a process we followed. So if we want to change our processes, I would request that the processes be outlined further, and I will task you as a commission to look at that from a policy direction. Thank you.
Mr. Manager. Commissioner Maisha, you ready to vote?
Yes.
All right, Madam Clerk, you want to call the roll, please?
Commissioner Maschine,
Yes.
Commissioner Velasquez is absent, Commissioner Lansman,
Yes.
Vice Mayor Rose,
Yes.
Mayor Danziger,
Yes.
Mayor, the motion carries.
Thank you. Could we get a motion to adjourn?
Motion to adjourn?
Second. Aye.
Aye.
All in favor, say aye.
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 See you all in 7 minutes.